May it please the court, my name is Laffin, L-A-F-F-I-N, initial DJ, and I appear for the plaintiff. This is an application by the plaintiff, Sol Baez, to seek the court's relief from the termination of the lease by GUCC and to enforce the orders for a further 5-year lease. Your Honour, it is submitted that based on the facts, there is two principal issues in this case that arise, namely, whether the termination of the lease sought by GUCC is effective, and whether the statement by Maloney to Baez that they would look after him at the renewal time could give rise to estoppel. Firstly, I would like to draw Your Honour's attention to the termination sought by the GUCC. It is submitted that this termination is ineffective and that the plaintiff has the right to complete the lease and remain the tenant for the remaining 6 months. It has been defined that a party has the right to terminate a contract under two ways, either by their contractual rights or the rights implied by the common law. Under common law, a party has the right to terminate a contract if the other party has failed to perform terms of the contract, committed a serious breach of an intermediate term, demonstrated unwillingness or inability to continue with the contract, constituting a repudiation or anticipatory breach of the contract. A party has the right to terminate a contract under their contractual rights if the other party has breached an essential term, committed a serious breach of an intermediate term, or the contract expressly provides for the termination in the particular situation. Under the circumstances, GUCC have sought to terminate on a breach of the contract, in particular, a breach of an essential term of the contract being section 29.1, subsection C of the lease, and have elected to terminate the contract under their contractual rights. This section of the contract outlines that the time is of the essence in relation to the reopen date, and that if the tenant fails to complete the refurbishment by the reopen date, then GUCC shall have a right, exercisable at its discretion, to terminate this lease and require the tenant to vacate the premises within 21 days. At the time of the breach occurring, Baez had notified GUCC a week prior to the deadline, advising that there had been some major setbacks and that the reopen date would be delayed. The plaintiff has sought to do the right thing and notify the other party of the delays outside his control. By doing this, the plaintiff has shown that he is still willing and able to complete the contract. It could be argued that there was estoppel arising from the Secretary's comments. However, it is conceded, as per Legione and Haitley, that the court would find that estoppel could not be considered under those circumstances. It was at this stage that it was open to GUCC to terminate on the basis of an anticipatory breach prior to the time for actual performance, which was outlined in the case of Foreign and White. The case further outlines that the innocent party also has the option to wait until the time for performance and accept the failure to perform, and accept it as an actual breach of an essential term of the contract. It is also provided that if the innocent party does not elect to terminate the contract prior to the performance date, then the contract will remain as is for the benefit of both parties, which then allows repudiating party to change their mind and complete the contract. In Kelly and Desno, a contract will not automatically be terminated if there is a breach or repudiation by one of the parties. The innocent party has the choice to either accept the breach of contract and terminate it, or affirm the contract. This means that due to the doctrine of election, once the party elects to affirm the contract, they will be prevented from terminating the contract at a later date, which was outlined in Sargent and ASL. Further, that once an election is made, that it is final, as per Wendt and Bruce. This applies to the current circumstances on the basis that GUCC had the opportunity to exercise their rights under the contract for the anticipatory breach by Baez. However, this option was not taken, which is their contractual right. It is also their right to wait until the anticipatory breach has crystallized and become an actual breach of the contract. It is submitted that this option was not taken by GUCC either. In Sargent and ASL, it advised that an election will occur if there are words or conduct consistent only with the exercise of one of two sets of rights and inconsistent with the exercise of the other by a party with the requisite knowledge, and the time for making the election has arisen. It can be broken down into simpler elements as follows. Has the party elected by unequivocal words or conduct? Did the party have knowledge of the necessary fact that imply an election was made? has the time for making an election arisen? It is submitted that GUCC had made a valid election by their conduct, and based on their conduct, they have sought to affirm the contract. This is evident from the conduct of obtaining rent for the tenancy of Baez. It is further submitted that the GUCC had knowledge of the necessary fact that would imply an election is available, which GUCC were aware that there was going to be delays in the reopen date, and had the option to affirm or terminate the contract. The time for making the election had occurred as they had the opportunity to elect when Baez first notified GUCC of the delay. GUCC also had the chance to make the election when the breach crystallised into an actual breach. However, neither option was sought by GUCC. In summary, the contract was kept on foot on the basis that GUCC had the opportunity to elect to terminate the contract, but chose to affirm it instead. This was evident by their conduct to receive rent from Baez. As per Tropical Traders and Gunan, if the context of termination and affirmation, the court will be concerned with whether the elector had acted in a manner consistent with the continued existence of the contract. It is submitted that the court would find that GUCC acted in a manner that would be consistent with the continued existence of the contract, as they not only accepted the first initial rent, but they continued to receive it for a period of 4 years, and thus admonished the breach altogether. It is further submitted that if the court were to find that the termination was effected even 4 years after the breach had occurred, even if their conduct amounted to affirming the contract, then it would open the floodgates for any number of cases to come before the court, because certainty would be out the window, and would allow for any lessor to end a contract at any point. I can confirm that the plaintiff has been advised that this is a more likely option with regards to the two issues, and that it is his best interest to obtain the further 6 months and opt out and relocate to a new area. Secondly, I'll draw your Honour's attention to the statement made by Maloney to Baez in relation to the renewal of the lease. It is submitted that the plaintiff would have not signed the contract had he not been assured by Maloney at the time of signing that he would be looked after. The plaintiff has been advised of concerns regarding this issue and the likelihood of overturning the Court of Appeal decision of Crown and Cosmopolitan Hotel, which it is submitted is relevant to the current circumstances. However, there are minor factual differences between the current case and the Crown case. The main one being the difference in representation, namely that in the Crown case they were given the lease at the meeting, however it was not signed at this stage, but later on after continued negotiations. In the current circumstances, Baez had advised Maloney that, I need these 5 years, to which Maloney responded, we'll look after you at renewal time. The lease was then signed by Baez immediately after, under the assumption he would be able to renew the lease for a further 5 years. The cases of Waltons and Mayer, and Silovi and Barabro were some of the initial cases to deal with the relevancy of the assumption or expectation. Justice Brennan, in the Waltons case, took the view that a relevant assumption or expectation was made, then a particular relationship then existed and would exist between the defendant, and that the defendant would not be free to withdraw from the expected legal relationship. However, Justice of Appeals Priestley, in the Silovi case, had a different view and outlined that equitable estoppel operated upon representation or promises as to future conduct, including promises about legal relations. His Honour further expanded on this in the case of Ostottel and Franklin's by outlining that an assumption or expectation that a contract will come into existence or a promise be performed or an interest granted to the plaintiff by the defendant. With respect to the 6 elements required to establish equitable estoppel raised by Justice Brennan in the Walters and Mayo case, it is submitted. Baez assumed a particular legal relationship, and GUCC would not be free to withdraw from the expected legal relationship. GUCC has induced Baez to adopt the assumption. Baez has acted on the reliance of this assumption. GUCC knew or intended Baez to do so. Baez's actions or inaction would occasion detriment if the assumption was not fulfilled. GUCC had failed to act to avoid that detriment by fulfilling the assumption. Under those circumstances, it could be argued that due to the assumption that Baez had received assurance at the meeting immediately prior to signing the lease, that this could be the differing factor between the current case and the Crown case. However, it is conceded with respect to this issue and to the plaintiff's case that the court will likely find that it's not a large enough factor to overturn the Crown case, especially when considering the principal cases that have defined the doctrine of promissory estoppel. In particular, the Legioni and Heatley case, in which large emphasis was placed on the need for the promise to be clear and unambiguous, which under the circumstances is not the case. Further emphasis to this principle was provided in the Crown case. The Court of Appeal agreed with the statement provided by Justice Hargrave in the Supreme Court of Victoria in saying that a reasonable person in the parties could not have understood the statements that the tenants would be looked after in renewal time to amount to a binding contractual promise to renew the 2005 leases for a further 5 years, and described the statement as merely vaguely encouraging. It is submitted that with respect to the current case, that Baez faces the same problem, and it is conceded that the statement by Maloney to Baez was unclear and unambiguous. In summary, Your Honour, it is submitted that this case slightly differs on the basis of representation, and the difference in the statement being applied to the situation. However, it is conceded that with respect to common law, that the statement is ambiguous and unclear, and therefore it is unlikely that the court would find that a minor difference in the factual basis would amount to overturning the Crown case. Thank you.